Friends, I am Vijay Kumar, Deputy Secretary in the Government of India. This is my second talk on Delegation of Financial Powers Rules 1978. In this talk, I will discuss 6 middle length and a little difficult rules, namely rules 8, 15, 17, 21, 22 and 24. First, rule 8. This rule is about two things. An illustrative definition of primary units of appropriation and an illustrative list of such units. As per the sub-rule 1 of this rule, a grant or appropriation for charged expenditure is distributed by subheads or standard objects under which it shall be accounted for. Each such subhead or standard object against which the provision for expenditure appears constitutes a primary unit of appropriation. The primary unit may include provision for both voted and charged expenditure, and in that case the amount of each is shown separately. You may like to consult the pink colored booklet of detailed demands for grants. Every year, every ministry, department prepares it and submits it to the Lok Sabha along with the budget proposals. This booklet contains nearly 15 kinds of information. The first item in this booklet is the detailed demands for grants. When you consult this item a little closely, you will find that it has been classified into tiers, which are denoted by digits. These tiers cannot exceed 6. These are: first, major heads in 4 digits and they denote function. Second, sub major heads in 2 digits and they denote sub function. Third, minor heads in 3 digits and they denote program. Fourth, subheads in 2 digits and they denote a scheme. Fifth, detailed head in two digits and they denote sub-scheme. Lastly, the sixth, called object head, in two digits and they denote primary units of appropriation against whom the provisions for expenditure are shown. The illustrative list of primary units of appropriation given in Subrule 2 of Rule 8 include: first, salaries; second, wages; third, dearness allowance; 3A, overtime allowance; 4A, travel expenses; 4B, conveyance allowance; 4C, deputation and travel abroad of scientists; 5, office expenses; 6, payments for professional and special services; 7, rents, rates and taxes or royalty; 8, publications; 9, advertising, sales and publicity expenses; 10, grants in aid or contributions or subsidies; 11, scholarships and stipends; 12, hospitality expenses or sumptuary allowances; 13, secret services expenditure; 14, major works; 15, minor works; 16, machinery and equipment or tools and plant; 17, motor vehicles; 18, maintenance; 19, investments or loans; 20, materials and supplies; 21, interests or dividends; 22, pensions or gratuities; 23, depreciations; 24, inter-account transfers; 25, write-off of losses; 26, suspense; 27, other charges. The Finance Ministry may add to the primary units specified in Subrule 2 any other primary unit or prescribe an entirely different set of such units. In the context of Rule 15, it may be relevant to mention that the Government of India has traditionally refrained from insuring its own properties and assets primarily because of the huge premium expense such an exercise would entail. These assets include the Parliament House, various government buildings, electrical installations, water pipelines, ports, airports, railways, etc. Accordingly, Rule 15 provides that government property, both movable and immovable, shall not be insured, and no subordinate authority shall undertake any liability or incur any expenditure in connection with the insurance of such property without the previous consent of the finance ministry. This rule provides exception in respect of the following cases. A. On the insurance of materials and equipments received on loan or as aid from foreign governments or international or other organizations if, according to the terms of contracts or agreements, insurance of such materials and equipments is necessary. B. For booking of goods by rail or road, enhanced risk rate prescribed, that is, additional charges above those prescribed for booking of goods at owner's risk rate, being in the nature of insurance charges. In cases where there is only one set of rates for carriage of goods and there are no alternative owner's risk rates, such charges are to be treated as freight charges under serial number 6(1) of Annexure to Schedule 5 of these rules and regulated accordingly. Moreover, in cases where it is decided to insure properties or goods under the direct or indirect control of the central government, the departments of the central government concerned shall effect the insurance only with a nationalized insurance organization and follow the procedure that may be laid down by the finance ministry from time to time. Motor vehicles owned by the central government used for purposes not connected with any commercial enterprise are exempt from compulsory insurance against third party risk. Rule 17 provides that a department of the central government or an administrator or any other subordinate authority may waive the recovery of an amount disallowed by an audit officer or the accounts officer or otherwise found to have been overpaid to a government servant if the amount disallowed has been drawn by the government servant concerned under a reasonable belief that he was entitled to it, and if, in the opinion of the aforesaid authority, the recovery will cause undue hardship or the recovery is impossible. However, the above authorities shall not have the powers to waive recovery. First, of emoluments of the nature of pay, as defined in Fundamental Rule 9, Sub-Rule 21, where the overdrawal has been occasioned by delay in notifying promotion or reversion, or where such overdrawal has been disallowed by the audit officer or accounts officer after 1 year of the date of payment. Second, where the recovery relates to a gazetted government servant or where the amount involved does not exceed 2 months' pay of the government servant concerned. This rule also provides that the powers of audit officers and accounts officers to waive objections to or to forego recovery or irregular expenditure in individual cases shall be such as may be laid down separately under general or special orders of the central government issued from time to time. Rule 21 provides that, subject to the provisions of these rules and the provisions of the general financial rules governing the purchase of stores for the public service, a department of the central government shall have full powers to sanction expenditure for purchases and for execution of contracts, including agreements or contracts for technical collaboration or consultancy services. This rule further provides that this power shall be exercised up to rupees 20 crore for open or limited tender contracts, up to rupees 5 crore for negotiated or single tender or proprietary contracts, and up to rupees 2 crore for agreements or contracts for technical collaboration and consultancy services by the secretary of the department concerned. However, contracts or purchases, amount of which exceeds these values in the categories stated, shall require the approval of the minister in charge of the department. Cases where the award of contract or purchase or consultancy is inseparably linked with the project or scheme and forms a part of the proposals for standing finance committee or committee on non-plan expenditure or expenditure finance committee or cabinet will be processed as per the financial limits laid down for sanction of such schemes or projects by the competent authority. In this rule, the word contract includes miscellaneous contracts such as handling contracts and leases. Leases for hiring, accommodation for office, residential and other purposes shall, however, be regulated under item 16 of the annexure to schedule 5. If a contract extends over a period of time, the total value over the entire period of currency shall be taken for the purpose of applying the limit. Further, a limited or open tender which results in only one effective offer shall also be treated as a single tender contract. Rule 22, which is about trading operations, provides that, notwithstanding anything contained in these rules, all proposals of the following nature shall be referred to the Finance Ministry for concurrence before approval. A. For the purchase of commodities, value being above rupees 1 crore and not intended for government consumption, but for sale or issue to the public, state governments or any other authority. B. For the fixation of prices in respect of direct trading operations of government, value being above rupees 1 crore. And C. From government companies and undertakings which may be referred to the government for fixation of prices for their products or stocks. In this rule, government company has the same meaning as in the Companies Act. Rule 24 provides that the departments of the central government and administrators shall have full powers to sanction sale or dismantlement of public buildings other than a purely temporary structure, provided these powers are exercised with the concurrence of their financial advisors. This rule further provides that 1. No public building shall be sold or dismantled unless it has been previously ascertained that it is not required by any other department of the central government. 2. No public building shall be demolished unless it is structurally in a dangerous condition or is beyond economic repairs and has been certified as such by appropriate technical authority, or it is necessary to vacate the site for constructing a more important government building or structure. 3. A public building, the sale or dismantlement of which is sanctioned in exercise of the power conferred by this rule, shall be disposed of by public auction through the Central Public Works Department or the local Public Works Department in areas where the Central Public Works Department does not operate. The power conferred by this rule shall be exercised only if the administrative control of the building vests in the authority sanctioning its sale or dismantlement. The departments of the central government and administrators shall have full powers to sanction sale or dismantlement of purely temporary structure. A purely temporary structure means a structure the life of which is not more than 2 years. The chief engineer and the additional chief engineers and other officers of the Central Public Works Department shall have the powers specified in paragraphs 126 and 127 of the Central Public Works Department Code in regard to sale or dismantlement of public buildings under the administrative control of that department. Ministry of External Affairs shall have the powers to sanction sale and dismantlement of public buildings abroad, the book value of which does not exceed rupees 1 crore. The certificate from the appropriate technical authority is not necessary in such cases. In brief, this is about rules 8, 15, 17, 21, 22 and 24 of the DAPR, which may be said to be difficult. In my third and final talk on DAPR, I will cover rules 4, 10, 11, 13 and 18, which are lengthy and complex ones. Thanks for patient listening.